Look, the redevelopment process is essentially the government coming in and saying to a private homeowner, I can do a better job of making your property, of managing your property than you can do. And if the government is going to do that, it's appropriate that the government take the necessary steps to make sure folks are aware of the fact that the government wants to do that. I think that what's probably more important to this case than the notice aspects is that the courts determined that the city of Long Branch didn't provide enough evidence that the properties in Metosa were in fact properties that needed to be redeveloped. And the reason that the court found that is because the fire marshal did drive-by inspections looking at cosmetic details and determined that because a wall, or not even a wall might be cracked, but a brick might be cracked or some other cosmetic detail was lacking in the property, it needed to be redeveloped and was properly defined as being blighted. And the court properly said that that's not enough. You need to go back and you need to figure out why these properties are in fact blighted. And I think that one of the reasons that the case ultimately settled was because the city of Long Branch couldn't do that.
Mr. Aaron, on its face, that doesn't sound right. The fire marshal just driving around and noting that some bricks are out of alignment or there's a pothole. I mean, is that what happened? Is that how the city determined that certain areas were blighted?
The answer is absolutely not. Keep in mind that this was not an area in need of redevelopment in itself. This was part of a much larger area that was all declared an area in need of redevelopment at the time. What was not in the reports were the growing number of vacancies, the deterioration of properties, the crack houses that existed, the overcrowded conditions that existed in the immediate area, the landfill that I mentioned, and the city was not afraid of a remand hearing.
None of that was in the Metosa area, though. None of those things.
But that was not, the Metosa area was not a separate area. That is my point. It was part of the entire area. One of the arguments that Metosa had was you don't need our area to do your redevelopment project. That was another area that was discussed, and the city would have had to deal with that on remand. But from the city's perspective, the city settled this case, not because it was afraid of the remand, but several things happened. One, the economy collapsed. Number two, the developer who had the contractual rights to develop the area said to the city, we're not developing anymore because we can't make any money. And C, there was an agreement that was reached that kept the area in need of redevelopment, allowed the property owners to keep their homes and actually get developer status, which is in the agreement. It allowed the developers to maximally develop those properties that they've already acquired in the area. And of the 36 parcels that were in the area, the developers controlled roughly 20. 16 were in litigation at the end, and some of those 16 people, in fact 3, had already opted out and asked their properties to be acquired. Additionally, the city would have been put in a difficult position, if not impossible position, because without a developer, the city under statute is obligated to buy the properties. And under their agreements, the developers would fund it. If there are no developers, then it would have to be funded by public money, which would have cost the city millions and millions of dollars based on the date of condemnation and the date of valuation, which would be at the height of the market and have no one to develop the property in accordance with the plan. So the settlement made sense.
The economy has something to do with this settlement.
More than a little bit.
More than a little bit. Let me ask this question, because I think for most people who followed this, they know eminent domain abuse. They know some of the allegations have been floating out there. First, that the developers intentionally purchased certain properties in the Metosa area, boarded them up to depress value. And also, there's a feeling out there among some people that, you know, the idea of conveying people's homes to private developers for profit doesn't sit well with them. I'm going to ask you both to respond to that. Number one, are the allegations true? And number two, is there just a general discomfort politically, emotionally with this process right now in Monmouth County?
Well, first of all, the area was declared in need of redevelopment in 1995. The plan for the development was done in 1996. There were no developers for 5 years. So the city didn't do this and declare the area in need of redevelopment knowing that 5 years later they would find someone to come in and develop. So that in itself is not factually true. It cannot be sustained. With respect to the value of the property, under state statute, when the city files a complaint that says we're going to take your property, that date sets the date of valuation. And here, coincidentally, had the property owners allowed their properties to be taken, they would have been valued as of December 2005, the very height of the market. And the developers and the city would have to pay that value, not the value that exists in 2010, so that the property owners would have gotten far, far more money now than conceivably even their properties are worth today, even though they own them.
But they didn't, that's not what they were after. They wanted to keep their homes. They didn't want to maximize the value of their homes and go somewhere else. They wanted to stay. They'd been there for 30, 40 years.
Well, let me ask you, Mr. Healy, how could this process be improved? I mean, how could the eminent domain process, the statutes, the way the courts look at it, how could this be improved so that people have a clear understanding of what their rights are, A, and B, municipalities have some indication as to what the law is before they proceed down this path? Because it seems very subjective and obtuse, at least to me.
I think that a couple of things can be done. I think that there could be a clearer, more objective understanding of what blight is, whether that be done by legislation or whether it ultimately be done by the courts. I think the courts are making steps to make the understanding of blight much more specific than the statute reads. And I think that the other thing that can be done is to make sure that there are adequate procedural protections for homeowners.
Mr. Aaron, you disagree with that?
No, we agree. After 28 minutes, we finally agreed. The whole bone of contention is how the statutes are written and whether or not whether the legislature wants to keep the process of redevelopment and the use of eminent domain alive in the state of New Jersey. From a general municipal standpoint, if you don't have redevelopment with the ancillary powers that it gives the government, given the state of economy today, given the COA obligations, given all of the DEP regulations, chances of redevelopment become slim and none unless you have these powers.
Thank you both very much. That's all the time we have for this episode. I'd like to thank our guests for an informative discussion. Join us next time for Outlook Monmouth. And again, thank you both.
Thank you.
Thank you.